Imagine this. You sue someone for breaking a contract. You win. But you spent money on a lawyer, you bought a plane ticket to get to court, and you spent, days preparing. Do you get that money back?
That's the million-dollar question, isn't it? Or in this case, maybe the $1,000 question.
Exactly. So today's deep dive is into that harsh reality of damages, the specific costs of the pursuit of justice.
And we're going to ground this conversation in a specific legal text, Mater v. Stephenson. It's a 1976 Supreme Court of Wyoming case.
Right. And our mission today is to really rigorously dissect when and why a court denies recovery for expenses that honestly seem logically necessary to win a lawsuit.
Precisely. And to do that, we've got a bit of a roadmap.
Okay, lay it out for us.
First, we'll define the doctrinal rule on cost recovery. Then second, we're going to put the Mater case through a really strict element-by-element FIRAC analysis.
Okay.
Third, we will use what I call a visceral hypothetical to really test the limits of this rule. And then finally, we'll synthesize a diagnostic checklist, something you could use for an exam.
I like a checklist. Okay, let's get into it. The doctrinal analysis. So, in a contract dispute, if the defendant's failure to pay is, say, unjustified, does that automatically open the door for the plaintiff to recover all the costs associated with fixing that wrong?
You would think so. It seems like common sense. But in American law, the general answer is no.
No.
No. The hard rule, the one we find in the text, is that recovery for costs is purely statutory.
Purely statutory. What does that mean exactly?
It means that if there isn't a specific law, a statute written down by the legislature that says you can recover a certain cost, then you can't. It's not about fairness. It's about what the law explicitly allows.
Wow.
Yeah. And for specific expenses, like, say, attorney fees, they're not recoverable unless one of two very specific conditions is met.
Okay, what are the two conditions?
The first one is statutory authority. So a law exists that says for this type of case, the winner gets their legal fees paid.
And the second?
The second is a contractual agreement. The contract itself has a clause that says, hey, if we end up in court over this, the loser pays the winner's legal fees.
So if it's not in the law and it's not in the contract, I'm just paying my own lawyer.
You're paying your own lawyer. That's the American rule.
Okay. And what about things like travel expenses or, just the time you spent preparing for the case?
Those are even tougher. For those, there's almost never a statutory provision for recovery. The court just sees those as the personal cost of deciding to go to court.
That is a tough pill to swallow. Okay, that rule is our baseline. Now let's test it. Let's analyze Mater v. Stephenson. First, what are the legally dispositive facts?
Okay, so the facts are pretty straightforward. The plaintiffs, the Maters, sued the defendant, Stephenson, over a contract. The court awarded the Maters the $1,000 they were owed, plus about $143 in interest.
So they won.
They won. And the court even said Stephenson's failure to pay was unjustified.
Okay.
But the Maters appealed.
Wait. They won, but they appealed. Why?
Because they were denied the additional damages they asked for. The costs of winning.
Ah, okay. What were those costs?
There were three specific items. First, $500 for their attorney's fee.
Makes sense.
Second, $212 for air transportation. They had to fly back from Kentucky for the trial in Wyoming.
Wow. And the third?
This one's my favorite. $500 for time spent traveling, making phone calls, and what they actually call the pursuit of justice.
The pursuit of justice. I love it. They actually put that on the bill.
They did. And the lower court said no to all of it. So they took it to the Supreme Court.
Okay, so we have the facts. And what was the core legal issue?
The issue was simply whether a prevailing plaintiff in a contract action can recover attorney fees, travel expenses, and costs for time spent in the pursuit of justice when there's no statute or contract that allows for it.
It's a clean question. So what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements for us.
The court applied the rule that costs and fees are not recoverable by a party absent specific authority. And we can break that rule down into three elements, mapping directly to what the Maters asked for.
Huh.
Element one is for attorney fees. It requires either statutory authority or a contractual agreement. Element two, for travel and incidental expenses, requires a statutory provision.
And the third?
Element three, for time and preparation, also requires a statutory provision.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, attorney fees?
Okay, so the sub-issue was, did the Maters have a contract or a statute to back up their $500 legal fee claim?
Right.
The court looked through the record, looked at the contract, looked at Wyoming law, and the text explicitly notes the absence of statutory authority or contractual agreement. Neither one existed.
So no recovery.
No recovery. And what's really key here is that the unjustified nature of the defendant's actions, it just didn't matter for this part of the analysis.
Understood. Now, what about the second element, travel expenses?
The sub-issue here is that $212 airfare from Kentucky recoverable. The court just applied the rule flatly. They said, nor are travel expenses in connection with the suit recoverable.
So they just looked for a statute.
Yep, they looked for a statute that authorized travel reimbursement for a litigant, and, well, they found none. So the conclusion was that the airfare is a personal cost, not a recoverable damage.
Even though they had to be there to win the case.
Correct.
And finally, the third element, the claim for time in pursuit of justice.
Right. The sub-issue was, can that $500 for time, calls, and just the general pursuit of justice be awarded?
And I'm guessing the answer is no.
A very firm no. The court stated it explicitly. There is no statutory provision for recovery of travel expenses or time for preparation of a lawsuit. Pursuit of justice is not a legal category for damages.
So if it's not written down in a law somewhere, it doesn't exist in the eyes of the court.
Exactly. Since recovery is purely statutory and there's no statute, the claim fails.
And after analyzing all the elements, what was the court's final conclusion?
The holding was affirmed. The Supreme Court of Wyoming agreed with the lower court. The Maters got their $1,000 plus interest, but they were strictly denied all requests for attorney fees, travel, and preparation costs.
So they won the $1,000, but they were out over $1,200 in costs.
That's the math. He literally paid over $200 for the privilege of winning.
That is rough. I want to test the limits of this rule now with a hypothetical.
Let's do it.
Okay, let's call it the millionaire commuter, hypothetical. Imagine a plaintiff lives on a space station. Someone in Wyoming owes them $50, just $50.
$50, okay.
The refusal to pay is completely malicious. The person in Wyoming is just being a jerk. So our plaintiff spends $100,000 on a rocket ticket to get to court.
100 grand, okay.
And another $50,000 on a lawyer? They win. They get the $50 judgment. The question is, under Mater, do they really take a net loss of $149,950?
Yes, absolutely. We have to apply the Mater rule ruthlessly.
How?
We run the checks.
Yeah?
Check 1. Is there a contract saying loser pays rocket ship fees?
No.
Check 2. Is there a Wyoming statute that says plaintiffs recover space travel costs?
I'm going to go with no on that one.
Then the result is clear. The plaintiff gets their $50. They eat the $150,000 loss. The court doesn't care about the net loss, only the legally authorized damages.
But that's absurd.
The court would say the plaintiff chose to spend that much money. The economic wisdom of the lawsuit is the plaintiff's problem, not the court's.
Wow. Okay, one more quick one. What if the plaintiff lists emotional exhaustion from the pursuit of justice as a cost?
Denied immediately. Because, as we saw in Mater, pursuit of justice expenses are not a recognized legal category for these kinds of damages. If it's not in the statute, it doesn't exist. That stress is just seen as the price of admission to the legal system.
This is all incredibly helpful. So let's distill this into something actionable. Can you give us a step-by-step diagnostic checklist for a student or anyone facing a similar issue?
Absolutely. It's a 4-step checklist. Step 1, identify the extra damages. Separate the actual debt, the $1,000, from the costs of fixing it. The fees, the travel, the time.
Okay, separate the debt from the costs of collection. Step 2.
Step 2, the 2-pronged check for attorney fees. Ask yourself 2 questions. Is there a written contract clause shifting fees? And is there a specific statute authorizing fees for this type of case? If the answer to both is no, you stop. No recovery.
Stop right there. Got it. What's step 3?
Step 3, the statutory check for costs and travel. Ask, does the statute explicitly allow recovery for things like travel or preparation time? And you have to remember, the default answer is almost always no.
Recovery for costs is purely statutory.
You've got it. And that leads to the final step. Step 4, the pursuit of justice trap. If you see facts mentioning these generic costs, seeking justice, time spent, frustration, flag it immediately as non-recoverable, unless there's a specific law.
Yeah.
Don't fall for how fair it sounds.
That is crystal clear. It's not about fairness, it's about authority. It's about what is written down.
Precisely.
You know, this leaves me with a final sort of provocative thought. If the law requires you to spend more money to prove you are right, then the value of being right, Is the pursuit of justice actually a rational economic decision?
That's the core question, isn't it? And Mader suggests that sometimes the smartest legal move is to walk away from a fight you know you can win, simply because you can't afford the victory.
A sobering thought. Thank you for diving deep with us into the mechanics of Mader v. Stephenson.
My pleasure. It's a harsh but important lesson.
And a quick reminder to everyone listening, we are strictly analyzing the provided text and not offering legal advice. If you've got a contract dispute, find a lawyer.
And ask them about their fees up front.
Thanks for listening. We'll see you on the next deep dive.